Good day, everyone. I am Mary Jimenez, Bscn 4A, and in this video presentation, I'll be discussing Rule 117 of Rules of Criminal Procedure, also known as the motion to quash. This rule is one of the most important safeguards in our justice system. It gives the accused the right to question or challenge the validity of the information or complaint filed against them before the trial even begins. In simple terms, it allows the accused to say, "There's something wrong with this charge, and it should not proceed to trial." Through this presentation, I will explain the meaning, purpose, and the different grounds of filing a motion to quash and show how this rule upholds fairness and due process in our court. So, join me as I explore the importance of Rule 117, motion to quash, and how it protects the rights of every person accused of a crime. In Section 1, and Rule 117 or motion to quash, the time to move to quash. At any time before entering his plea, the accused may move to quash the complaint or information. In Section 2, form and contents, the motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no grounds other than those stated in the motion, except lack of jurisdiction over the offense charge. In Section 3, or the grounds, the accused may move to quash the complaint or information on any of the following grounds. First, the facts charged do not constitute an offense. Second, the court trying the case has no jurisdiction over the offense charge. Third, the court trying the case has no jurisdiction over the person of the accused. Fourth, the officer who filed the information had no authority to do so. Fifth, it does not conform sustainability to the prescribed form. Sixth, that more than one offense is charged except when a single punishment for various offenses is prescribed by law. Seventh, that the criminal action or liability has been extinguished. Eighth, that it contains averments which, if true, would constitute a legal excuse or justification. And last, that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. And Section 4, amendment of the complaint or information. If the motion to quash is based on an alleged defect of the complaint or information which can be cured by amendments, the court shall order that an amendment be made. If it is based on the grounds that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment or the complaint or information still suffers from the same defect despite the amendments. In Section 5, effects of sustaining the motion to quash, if the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in Section 6 of this rule. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if it having made, no new information is filed within the time specified in the order or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody for another charge. In Section 6, order sustaining the motion to quash not apply to another prosecution. In exception, an order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3, paragraphs 7 and 9 of this rule. In Section 7, former conviction or acquittal, double jeopardy, when accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without express or otherwise terminated without his express consent by a court of competent jurisdiction. Upon invalid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or prostration thereof, or for any offense which necessarily includes or is necessarily includes in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following instances. A. The graver of offense developed due to supervening facts arising from the same act or omission constituting the former charge. B. The facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information. C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section 1, Paragraph 7 of Rule 116. In any of the foregoing cases where the accused satisfies or serves in whole or in part judgment, he shall be credited with the same in the event of conviction for the graver offense. In Section 8, Provisional Dismissal, a case shall not be provisionally dismissed except when the express consent of the accused and with notice to the offended party. The provisional dismissal of the offenses punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after issuance of the order without the case having been revived. With respect to the offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. In Section 9, failure to move to quash or to allege any ground therefore, the failure of the accused to assert any ground of the motion to quash before he pleads to the complaint or information, either because he did not file the motion to quash or failed to allege the same in said motion, shall be deemed a waiver or any objection based on the grounds provided for in paragraph 1, 2, 7, and 9 of the Section 3 of this rule.